Thank you for joining this virtual presentation of Oregon Pharmacist in Charge, or PIC training program. This presentation is part 3 of a 3-part series. The program was last revised in April 2024 and is designed to provide you with an overview of the Oregon Board of Pharmacy statutes and rules that pertain to the responsibilities of a pharmacist in charge. It is important to note that while we strive to keep this training current with applicable laws and rules, you are ultimately responsible for following the most current and effective laws and rules. In any instance where there's a conflict between the information presented here and the effective laws and rules, the laws and rules take precedence. So welcome to Module 3. This module will focus on current topics as the pharmacy landscape is constantly evolving, and will provide you with a list of valuable resources to help you navigate your PIC duties effectively. Now, let's talk about some current topics in pharmacy. In 2021, House Bill 2359 created the requirement for healthcare providers to work with a healthcare interpreter from a healthcare interpreter registry operated by the Oregon Health Authority to provide interpretation services. This interpretation requirement includes a requirement for interpretation in assigned language. These laws are in the statutes for the Oregon Health Authority and ORS 413, but apply to pharmacists and pharmacies. The board adopted 3 rules related to this legislation, requiring pharmacists to work with healthcare interpreters from the Healthcare Interpreter Registry to provide interpretation services. The first rule is in the Pharmacist Counseling Rule, in OAR 855-115-0145, and it states that when communicating, for example, counseling, patient care services, or billing, with a patient who prefers to communicate in a language other than English or communicates in a signed language, the pharmacist must work with a healthcare interpreter from the Healthcare Interpreter Registry administered by the Oregon Health Authority under ORS 413.558 unless the pharmacist is proficient in the patient's preferred language. The second rule is in the Drug Outlet Pharmacy Rules in OAR 855-041-1133. Similar language applies when an OHA interpreter must be utilized. There are 2 exceptions. A pharmacist who is otherwise required to work with a healthcare interpreter from the Healthcare Interpreter Registry may work with a healthcare interpreter who is not listed on the registry only if the pharmacist has made a good faith effort to obtain a healthcare interpreter from the registry and has found that none are available to provide interpretation, or has offered the patient the services of a healthcare interpreter from the registry and the patient declined the offer and chose a different interpreter. If the interpreter appears in person, the pharmacy must provide PPE to the interpreter. The pharmacy must maintain records for each patient encounter where the OHA registry interpreter was utilized or when a good faith effort was made, including the interpreter's full name, registry number, and the language interpreted. The third rule is also Division 41, OAR 855-041-1165 in the patient's medical record. The pharmacist must make a reasonable effort to obtain, record, and maintain the following information: the patient's preferred language for communication and prescription labeling. Some practical questions that you should ensure your pharmacy staff are able to answer include: how do you identify patients that would benefit from interpretation services? How do you document interpretation services provided? And how do you provide interpretation to a patient requiring signed language? In 2019, Senate Bill 698 added to the Board of Pharmacy statutes ORS 689.564, language requirements for prescription drug labels, exceptions, interpretation and translation services, rules. This bill required the board, in consultation with the Oregon Health Authority, to adopt rules to require that a pharmacy post signage to provide notification of the right to free, competent oral interpretation and translation services for patients who are of limited English proficiency. Rules adopted under this subsection also comply with relevant federal laws and regulations. The rules are found in OAR 855-041-1132 and require pharmacies to provide prescription drug labels and informational inserts in both English and the language the patient can understand upon the request of a practitioner, patient, or patient representative. The board is required to list at least 14 languages as determined in consultation with the Oregon Health Authority. The board will update the required languages at least once every 10 years. Institutional drug outlets are exempt from the requirements when dispensing a drug intended for administration by a healthcare worker. There are also similar rules in Division 43 for practitioner dispensing, Division 44 for charitable pharmacies, and Division 139 for telepharmacies. Here are some options for labels if the translation takes more room than is available on a traditional prescription label. Some practical questions your pharmacy staff should be able to answer related to dual language labels during an inspection include: how do you identify patients that would benefit from dual language labels? How do you ensure that prescriptions for dual language labels have been requested, have the dual language labels applied prior to release to the patient? Show me how you would create a label for this prescription in Arabic. Here's a sign for pharmacies in all 14 languages that meets the requirements of the law to post signage. The sign has been added to the board's website on the licensee's compliance page under resources. It is also linked here on the slide. In 2019, House Bill 2935 created new statutory language found in ORS 689561 related to prescription readers. The statute includes definitions of a person who is blind, which includes persons who are visually impaired or print disabled. A prescription reader, which means a device that is designed to audibly convey the information contained on the label of a prescription drug. The law sets forth the requirement for a pharmacy to notify each person to whom a prescription drug is dispensed that a prescription reader is available to the person upon request. And then, if the person informs the pharmacy that they identify as a person who is blind, the pharmacy must provide to the person a prescription reader and a label that is compatible with the reader. These statutes do not apply to prescription drugs dispensed by an institutional drug outlet or drugs administered to a patient in other healthcare settings. The bill required the Board of Pharmacy to adopt rules to carry out this section of the statutes, and each pharmacy is responsible for determining how they will meet the requirements in the rules. Here is the rule related to prescription reader accessibility. OAR 855-041-1131. The rules are essentially a repeat of the statutory language. There are similar rules in Division 43 for practitioner dispensing, Division 44 for charitable pharmacies, and Division 139 for telepharmacies. This slide shows some pictures of various prescription reader devices available on the market. Some questions that you and your pharmacy staff should be able to answer during inspection related to prescription readers include: do you know how to obtain a prescription reader and related supplies? Do you know what type of prescription reader your patient uses? Do you know how to set and use the prescription reader? Now let's turn our focus from accessibility topics to continuing pharmacy education topics. In 2019, House Bill 2011 amended ORS 676.850, which is the authority of regulatory boards to recommend cultural competency continuing education. The law requires the Board of Pharmacy to document participation in cultural competency continuing education by persons authorized to practice the profession regulated by the board, which means all of our licensees. The board adopted rules in 2021 that require a minimum of 2 hours of continuing education related to cultural competency for pharmacists, certified Oregon pharmacy technicians, and interns. The cultural competency continuing education hours count towards the total hours required for renewal for pharmacists and pharmacy technicians. This is a new requirement for pharmacy interns. This CPE requirement began with the licensing cycle beginning July 1st, 2021. through June 30th, 2023 for Pharmacist. December 1st, 2021 through November 30th, 2023 for interns, and July 1st, 2022 through June 30th, 2024 for pharmacy technicians. A cultural competency CPE can be any program approved under the law in ORS 413450. There's a list of these approved programs on the OHA website for CCCE, or it can be any other cultural competency CE that is approved for CPE credit. In 2021, there was another bill, 2021 House Bill 2078, which modified the pain management education requirements for pharmacists by amending ORS 413572. This law requires the Pain Management Commission to develop a 1-hour training for health professional, regulatory, and other health boards, including pharmacy. The updated curriculum must take into account the needs of groups disproportionately affected by adverse social determinants of health and related factors that influence how individuals experience chronic pain. The bill requires pharmacists to complete pain management education program at initial licensure and at least every 36 months thereafter. The board's rules require the program with each renewal, so every 24 months. Pharmacists must report completion of this OHA module with their renewal starting in 2025. Effective July 1st, 2023, new continuing pharmacy education rules became effective. The former rules in Division 21 were repealed, and licensees must now comply with Division 135. This new division outlines exactly what qualifies for earning CE credit hours. Good news, there's plenty of ways to fulfill your CPE requirement. Division 135 allows credit for activities that are structured programs. This includes traditional instructor-led programs, workshops, and even some demonstrations where you actively participate. You can receive credit for approved Q&A sessions. Don't ever underestimate the power of a good discussion. Participating in structured question and answer sessions on approved topics can also earn you credit. ACPE accredited programs. Look for programs that are accredited by the Accreditation Council for Pharmacy Education, or ACPE. These are guaranteed to fulfill your CPE needs. In addition, pharmacists may earn up to 10 hours of CPE per renewal cycle through ACCME accredited AMA Category 1 programs. Technicians can earn up to 6 hours of ACCME credit per renewal cycle. Did you know that you can also earn CE for attending a Board of Pharmacy meeting? You can earn up to 2 hours of law CE credit by attending a Board Pharmacy meeting. Now let's talk about what cannot be counted towards credit hours. Activities like social events, meals, and purely business-oriented sessions like voting or strategic planning discussions do not count towards CPE hours. Additionally, unstructured workshops, along with non-approved certificate programs, software training like iPledge, skills training like CPR or ACLS courses, are no longer eligible for credit. If you want a program that you are attending to count towards CPE credit and the program is not ACPE or ACCME accredited, you can submit an application that is available on the board website to request board approval. This must be submitted 45 days in advance of the program. There are also rules on how the instructor of a CPE program can obtain CPE credit in OAR 855-135-0040. Finally, the requirements for documentation of CPE when renewing have been updated. There are no changes to what types of CPE are needed or the amounts of CPE are needed, but there are clear rules on how CPE credit must be retained. For each board-approved or ACCME accredited program, which are not included in your CPE monitor, the licensee must ensure that the CPE credit was either recorded in the CPE monitor, which requires a paid version, or uploaded to the licensee's electronic licensing record with the board prior to submission of your license renewal. Licensees must retain documentation of completed CPE for 6 years and must provide this documentation if requested by the board. CPE monitor and your eGov profile count as retention. The Drug Supply Chain Security Act, or DSCSA, includes requirements that pharmacies must follow to protect patients from receiving harmful drugs, such as counterfeit or other illegitimate drugs. The DSCSA was enacted in 2013 to further secure our nation's drug supply. It creates a tighter, closed prescription drug distribution system to prevent harmful drugs from entering the supply chain, detect harmful drugs if they do enter the supply chain, and enable rapid response when such drugs are found. Pharmacy requirements under the DSCSA include confirming active licensure or registration of all entities. These are your manufacturers, repackagers, wholesale distributors, third-party logistic providers, and other pharmacies with whom you do business. Receiving, storing, and providing product tracing information. Only accepting prescription drugs that are accompanied by 3 pieces of product tracing documentation: transaction information, transaction history, and transaction statement. If the trading partner you purchased the drugs from does not provide all this documentation, work with them to promptly receive it. Storing the product tracing documentation you receive in paper or electronic format for 6 years. Generating and providing all product tracing documentation with the transaction if you sell a prescription drug to a trading partner. You do not need to provide this information when you dispense a prescription drug to a patient or if you sell to a pharmacy for dispensing to a specific patient. Having policies and procedures and using them to investigate and handle suspect and illegitimate prescription drugs received, which includes drugs that may be or have evidence that's counterfeit, diverted, stolen, intentionally adulterated, or unfit for distribution. This includes steps to quarantine and investigate suspect prescription drugs and determine if they're illegitimate. And if they are illegitimate, pharmacies should work with the manufacturer to take specific steps to ensure that patients do not receive the illegitimate drugs. Pharmacies must also notify the FDA and the trading partners they bought the drug from and sold the drug to. You can find more information by searching for drug notifications at www.fda.gov. On August 25, 2023, the FDA finalized its guidance on the compliance policies for the enhanced drug distribution security requirements under Section 582G1 of the Federal Food, Drug, and Cosmetic Act. The FDA's guidance document details that the FDA does not intend to take action to enforce requirements under Section 582G1 until after November 27, 2024. These requirements were originally slated to go into effect on November 27, 2023, and they will help improve the security of the drug supply chain by requiring trading partners to share electronic product tracing data. By exercising this enforcement discretion, the FDA has effectively provided a blanket enforcement delay for 1 year for all of the approaching 2023 requirements, including product tracing requirements and further extending product verification requirements enforcement. The FDA also noted that additional time was necessary for trading partners to move forward with capturing and sharing data in an electronic and interoperable manner. The guidance also grants enforcement discretion for product identifier transactional data and for any product that is introduced into commerce by manufacturers or repackagers prior to November 27, 2024. This is intended to allow any existing inventory in the supply chain to be exhausted. In 2019, House Bill 3273 established a drug take-back program to allow for the safe disposal of prescription drugs. The bill requires manufacturers of certain prescription and OTC drugs sold into Oregon to participate in the drug take-back program, and the Board of Pharmacy is authorized to assess fines of up to $10,000 each day a covered manufacturer does not participate in the program. The Oregon DEQ selects the take-back program operators who are responsible for establishing the statewide system for the collection and disposal of drugs that is funded by fees on covered manufacturers. Covered manufacturers are required to pay all program costs, including the cost of the collection kiosk and disposal services. The laws in ORS 459A.200 to ORS 459A.266 outline that criteria for authorized collectors, drop-off sites, covered drug collection events, and the disposal of covered drugs. The laws also require the program operator to promote public outreach and education about the safe disposal of drugs. The program is voluntary for pharmacies, but is encouraged as a valuable public safety service, and it is good for the planet, keeping pharmaceuticals out of the waterways. The measure requires the program operator to establish at least one drop-off site in each county in Oregon and in each population center, including at least one drop-off site for every 50,000 residents of a city or town located within a population center. The DEQ has an agreement with the Board of Pharmacy for our compliance officers to inspect these non-pharmacy drop-off sites. The bill also provides DEQ with enforcement authority, and it allows it to establish fees to pay for program administration. Over the past few years, there has been an increase in temporary, permanent, and emergency pharmacy closures. To ensure patient and board notification of these closures, the board adopted OAR 855-041-1092. Paren 1 concerns temporary closures and requires pharmacies to post notification of a temporary closure within 2 hours, which includes notification on telephone greetings and pharmacy-operated internet, such as the pharmacy's website. Postings must include the estimated time the pharmacy will be closed and provide patients with alternative options for receiving their prescriptions during the temporary closure. The rule also sets requirements for board notification of a temporary pharmacy closure. Paren 2 concerns permanent closures and requires pharmacies with clear direction on orderly disposition of prescription and non-prescription drugs, devices, and related supplies, and pharmacy records when a pharmacy permanently closes. The rule provides a list of items that must be completed prior to or on the date of or within 24 hours and within 30 calendar days of the permanent closure. Paren 3 concerns emergency closures due to circumstances like inclement weather, fire, property seizure, or bankruptcy, and requires the pharmacy to follow the temporary closure rules as soon as is allowed by the circumstances. While most Americans, over 90%, live near a pharmacy, many face deserts with limited access due to distance, which is about greater than 10 miles or 15 minutes from a pharmacy, or other barriers like transportation or language barriers. This can disrupt medication adherence and negatively impact health. So what's fueling pharmacy deserts? Several factors contribute to this growing issue. Smaller pharmacies struggle against big chains, as well as online retailers. Pharmacy benefit managers continue to decrease reimbursements for prescriptions, which impacts pharmacies serving lower income communities. Many health plans partner with specific pharmacy chains, excluding independent pharmacies. Recognizing the challenges posed by pharmacy deserts, characterized by the limited access to brick and mortar pharmacies, the Board of Pharmacy has introduced a number of regulations to enhance medication accessibility. First, for telepharmacies, in 2021, Senate Bill 629 and ORS 689-700 permit pharmacists to use telepharmacy to deliver pharmacy services to patients at remote locations. These telepharmacy establishments leverage technology and combine on-site pharmacy technicians with remote pharmacist supervision and patient care. This model ensures convenient medication access while maintaining crucial pharmacist oversight and guidance. Next is pharmacy prescription kiosks. These are strategically placed at locations like grocery stores or community centers. And these secure self-service kiosks dispense pre-labeled medications for specific prescriptions, eliminating the need for a full-service pharmacy presence. However, remote pharmacist involvement remains crucial, with professionals reviewing, verifying, and counseling patients virtually. And finally, we have pharmacy prescription lockers. Offering 24/7 accessibility, these secure lockers function as extensions of a brick-and-mortar pharmacy. Prescriptions are deposited within the lockers for convenient pickup, while virtual pharmacist consultations guarantee patients receive the counseling they need. These novel regulations aim to bridge the gap for individuals residing in pharmacy deserts ensuring convenient access to vital medications and pharmacist expertise, regardless of their location. In light of the ongoing opioid epidemic, the legislature has passed a number of bills and thus new laws related to access to short-acting opioid antagonists. Due to these new laws, a number of the board rules in OAR 855 were amended to use the term short-acting opioid antagonist instead of naloxone. There is a new product approved by the FDA, nalphamine, under the brand name of OPV, that necessitated the change in language. In addition, existing rules for pharmacy, dispensing, practitioner drug outlets, correctional facilities, community health clinics, and charitable pharmacies have been amended by incorporating a labeling exemption requirement that applies when a prescriber personally dispenses a short-acting opioid antagonist in the form of a nasal spray, per the directives of 2023 Senate Bill 450, which is codified in law at ORS 689813. Pharmacists may prescribe short-acting opioid antagonists per ORS 689802 and the rules found in OAR 855-115-0350. They may also use the statewide standing order issued by a state health officer with OHA to create a prescription and dispense to the patient requesting naloxone nasal spray or injection. If using the statewide standing order, the prescriber is the name of the state health officer on the order. The third way to prescribe is in progress, and that is under a statewide protocol recommended by the PFAC and approved by the board by rule. It is anticipated this protocol will be available in the summer of 2024. Please note that there are no requirements for pharmacists to have additional training, certification, or licensure by the Board of Pharmacy to prescribe a short-acting opioid antagonist. 2023 House Bill 2278 authorized a pharmacist to administer influenza vaccine to a person who is 6 months of age or older. 2023 House Bill 2486 permits an appropriately trained and qualified certified organ pharmacy technician or pharmacy technician to perform the physical act of administering vaccines under the supervision of an appropriately trained and qualified pharmacist. Prior to the administration of a vaccine, OAR 855-125-0305 requires the COPT or PT to receive practical training that includes infection control, recognition of anatomical landmarks, and competency in hands-on administration technique. And they must also hold active CPR certification issued by the American Heart Association or the American Red Cross or any other equivalent program that is specific to the age and population receiving the vaccine, contains a hands-on training component, and is valid for not more than 3 years. The rules also remove the previous rule requirement for the pharmacist to give a vaccine information statement to the patient and ensure it was read by the patient, and alternatively requires the pharmacist to ensure each patient receives a VIS. It adds pharmacist requirements for supervising interns and technicians who administer a vaccine, which include the pharmacist being immediately available to the vaccinator. It requires each drug outlet pharmacy to have policies and procedures for technician administration of vaccine and the disposal of drugs or devices, including hazardous and pharmaceutical waste. All drug compounding must adhere to the standards of the United States Pharmacopoeia, or USP, and the National Formulary, or NF, including USP 795, 797, 800, and 825. USP published its revised standards for the USP General chapters on November 1st, 2022. These new USP standards became effective on November 1st, 2023. Due to the numerous and complex process changes required for compliance, registrants may implement the revised USP 795 and 797 or utilize the previous 795 and 797 until the board completes rulemaking to require compliance with the 2023 version of these standards. This is anticipated sometime in late 2024 or 2025. Two frequently asked questions related to compounding involve compounding kits and flavoring. Pharmacies utilizing compounding kits are engaged in the act of non-sterile compounding. The packaging of these kits clearly indicates that these kits are for prescription compounding only. These kits contain bulk ingredients for prescription compounding, are exempt from the FDA's approval, and do not have manufacturer-approved labeling. Thus, following the compounding kit's instructions is not considered reconstitution per the manufacturer label. Under OAR 855, Division 45, a pharmacy engaged in non-sterile compounding must comply with the documentation, equipment, and training standards established in the USP Chapter 795, Pharmaceutical Compounding for Non-Sterile Preparations. As such, the pharmacy is required to complete a compounding record when compounding a drug product using a compounding kit. 2024 House Bill 4010 states the addition of flavoring to a drug intended for dispensation may not be considered compounding if the flavoring is inert, non-allergenic, and has no effect other than imparting a flavor to the drug or modifying the flavor of the drug, and does not constitute more than 5% of the total volume of the drug. The board anticipates rulemaking related to this bill in 2024, so stay tuned for more information on this topic. The Multidisciplinary Public Health and Pharmacy Formulary Advisory Committee, or PFAC, was convened in 2018 pursuant to ORS 689-645 and ORS 689-649. The committee is comprised of 2 physicians, 2 nurse practitioners, and 3 pharmacists who are appointed by the governor. The committee meets at least twice a year, but usually no more than quarterly. The rules related to the pharmacist authority and responsibilities when prescribing drugs and devices pursuant to the formulary and protocols that are developed and recommended by the committee can be found in OAR 855-115-0330 to OAR 855-115-0345. These rules articulate the authority and legal expectations for an Oregon licensed pharmacist who is practicing in Oregon to voluntarily participate in providing patient assessment and patient care services that may result in the issuance of a prescription by a pharmacist for an identified medical need. You can find the current formulary and compendia items in OAR 855-115-0340 and OAR 855-115-0345. Items may be added via rulemaking throughout the year. A pharmacist may prescribe an item listed in the formulary compendium pursuant to a diagnosis by a healthcare practitioner who has prescriptive authority and who is qualified to make the diagnosis. The diagnosis must be documented. Items currently listed on the formulary include blood sugar testing supplies, inhalation spacers, and blood pressure monitors. A pharmacist may prescribe an item listed in the protocol compendium pursuant to a statewide drug therapy management protocol. Protocols exist for things like contraception, vaccinations, tobacco cessation, HIV, PEP, and PrEP. Now let's wrap up this training with information on board resources. The most utilized resource is the board's webpage. In the top ribbon, you can verify a license or registration, as well as search the Board of Pharmacy website. In the 4 buckets below, you can find information on applicants. This is where you can find information on all the different types of licenses and registrations that can be applied for and information on each of them. In the licensees bucket, you can update your license or registration, find resources on controlled substances, PICs, CPE, compliance, and self-inspection forms. In the board bucket, it contains board meeting agendas and meeting summaries, videos, who the board members are. You can learn about the PFAC and review recently proposed or permanently adopted rules. In the resources bucket, there are links to pharmacy laws and rules, how to file a complaint, request public records, locate information on various professional topics, such as formulary and protocol compendia prescribing, position statements, and licensee statistics. With the board's online eGov system, licensees can maintain their own record and upload documents directly to their profile. To update your profile, go to the board website. In the licensees bucket, click on Update or Renew My License or Registration. For first-time users, you'll need to click on Register a new personal account or Register a new facility account. Returning users will need to use their previously created credentials to access their account with the mylicense.egov link. Once you're logged into eGov, use the menu in the upper left-hand side of the page to update your contact information, your address, phone, email, and employment. Remember, you have 15 days to do this. You can also upload documents such as the Pharmacist Pain Management CPE certificate or other non-ACPE CPE certificates. Also, in the menu box, you can renew your license, request certified copies of your license or registration, and pay invoices. Remember, CPE rules now require licensees to upload all non-ACPE CPE certificates into their eGov profiles. I showed you this slide in Module 1, but please make sure that each pharmacist and outlet has updated their work email and outlet inspection email addresses in eGov. Also, make sure that you're signed up to receive agency communications. Board of Pharmacy newsletters communicate important information to licensees and registrants and help you keep up to date. You are not automatically added to this listserv as it is maintained by NABP and not by the board. Don't forget that OAR 855-041-1035 requires a pharmacy to have 3 years of newsletters available in the pharmacy. They can be kept as hard copies or, if available online, staff must be able to access them on the pharmacy's computer system. You are automatically added to the board's listserv called Gov Delivery based on your license type. However, if you don't keep your email address updated with the board, you will not receive these time-sensitive notices. If you want to subscribe to board meeting agendas and rulemaking notices, you need to opt into these communications. You can sign up for newsletters, board agendas, mailings, and rulemaking adopted rules notices by clicking under the subscription links at the bottom of the board's homepage, or as shown here with the subscriptions and newsletters link in the resources bucket. Please know that there's a compliance officer on duty each day to respond to licensee and registrant questions. They can be reached by emailing pharmacy.compliance@bop.oregon.gov or by calling the board office at 971-673-0001. Because agency staff often work remotely, you may receive a faster response to an email versus a phone call. We understand that navigating board regulations can be confusing, so we're happy to help. When you have questions about the board's laws and rules, agency staff is here to offer assistance. What we can do, we can point you in the right direction. We can help you find relevant statutes and rules that apply to your specific situation, including links for easy access. We can share additional resources. If available, we can provide helpful information like past newsletter articles or board statements that address similar topics. We can offer you a starting point. Keep in mind that our resources are just that, a starting point, and we encourage you to explore the statutes and rules further for complete understanding. Here's what we can't do. We can't give you legal advice. Providing legal interpretations and explanations requires legal expertise, and we recommend consulting an attorney for specific legal advice. We can't predict board decisions. Each review of a case by the board is unique, and the board carefully considers each case before reaching a decision. We also can't offer guarantees. We can't guarantee you a specific outcome, but we assure you that the board follows a fair and thorough process. Finally, remember we're here to help. Feel free to reach out with any questions you have, and we'll do our best to assist you in navigating the regulations. Congratulations, you have completed watching Module 3 of the PIC training course. The program code for this module is plum, like the fruit, PLUM. You will need to select this code on the program quiz and evaluation that's located on the board's PIC webpage. Alternatively, you can use the QR code on the screen to be taken directly to the program quiz and evaluation. Please note that you will need to enter all 3 program codes for the modules before you complete the learning assessment and program evaluation. If you do not have all 3 codes, please go back and review the other modules to obtain the codes. Once you complete the learning assessment and program evaluation, a completion certificate will be emailed to you within 8 weeks. Please note that while this PIC training course is board approved for CPE, it is not accredited by the Accreditation Council for Pharmacy Education, or ACPE. Therefore, completion of this course will not automatically appear in the NABP CPE monitor. If you want to track non-ACPE credits like this program in the CPE monitor, pharmacists can upgrade to the NABP CPE Monitor Plus program for an annual fee. This upgrade allows you to manually upload credits from this program and others like it. Alternatively, you can upload the course completion certificate for this program in your eGov profile to comply with the CPE record retention requirements in OAR 855135. If you have thought of a question, we encourage you to email pharmacy.compliance@bop.oregon.gov so that the compliance officer on duty can provide a complete response to your inquiry. And just remember, the agency staff cannot give legal advice and may not be able to answer your question as asked. Thank you for participating in the PIC training